We have Harish Salve with us. I would say the country's topmost jurist and former Solicitor General. And I would say, as far as the Constitution is concerned, without hesitation, I would perhaps rate him one of the finest lawyers, advocates, and defenders of the Constitution in court and outside in the country today. Harish Salve, it's a privilege. Now, there is a parliamentary session on the Constitution. There's a political issue as well, because the government seems to be going into this session saying, listen, we have not done anything to compromise the Constitution, and yet there is this whole argument of Samvidhan khatre mein hai. Our Constitution is in severe danger. Let me begin with a broad question to you, Mr. Salve, and Rhythm is also going to join us on this, that in your view, is there a need for this ongoing debate? If so, why? And what purpose does it serve beyond political posturing? Mr. Salve.
So there is a need for this debate. And there is a need for this debate for two reasons. There was only one time where the Constitution came under a shadow. Of course, it's ironical that those who brought the Constitution under a shadow today are leading the charge of the Constitution being in danger. But it doesn't matter. It needs to be debated. Is there a threat to freedoms? Which brings us to the more important question of where does the threat to freedoms emanate from?
Yeah.
Now that we have put provisions of declaration of emergency under which constitutional rights can be eclipsed, as they were in 1975 and 76, where is this threat to the Constitution coming from? The threat to the Constitution comes from proposals which are defying the judgments of the Supreme Court without a full debate. When you talk of people, of sharing of resources in a particular manner, and when you are selling this idea of anarchy, saying that we must make sure that the poorest of the poor get an equal share of the resources of the country. These are fires which are lit, which become very difficult to douse. And once these kind of fires are lit on the ground, then the rule of law comes under a cloud. Governments are pushed to the corner where they have to suppress freedoms. And that's where things start unraveling. So, first of all, there must be an agreement on 2-3 issues if you have to prevent a threat to the Constitution. The constitutional institutions should be allowed to work in the spirit of the Constitution. And the two biggest constitutional institutions are Parliament and the courts. As far as Parliament is concerned, we need to have a rule of conduct of how Parliament should now be run. This kind of yelling and shouting, and we see this on TV, and it's disheartening. So many people there have worked very hard and want to make a speech. You can't hear what they are saying because there are some people who are shouting slogans. Parliament is disrupting. Parliament is meant to enact laws. Nobody is paying attention to that. You have to see how laws are enacted in the UK Parliament. There is a first reading, there is a second reading, there is a third reading, clause by clause discussion. When have you last seen that in Parliament? So this is how we have to restore the good sense of Parliament. I mean, important laws are passed in 45 minutes, and most of the time is wasted on rhetoric of relatively little national relevance in Parliament. I mean, the streets are there for protest marches. Parliament, you want to make a token protest, but Parliament must go on. So this is one important debate which people must have and come to a landing. The second is the working of the courts. And I say that the working of the courts is to some extent in a state of disrepair. It is in a state of disrepair for two reasons. The rule of law mandates the availability of judicial remedies. A judicial remedy which is interminably delayed is no remedy at all. What are people willing to do and put our heads together to find a solution to this huge pendency of cases? Can Parliament get together and find a solution? And it is not by amending law or simplifying laws or by rebranding certain laws. This has to be done to find out, do we need more investment in resources? The answer is yes. Where are we going to find the resources? How are we going to put them in? And the second, and I dare say, we need to set right the system of appointment of judges. None of your problems, including overreach by the court, and there have been frequent instances of overreach by the court, will be sorted unless you fix the system of appointment of judges. It is in serious disrepair. It doesn't work. Now, these are matters which, and other important issues of federalism, are matters which people who are elected to office must sit down and debate seriously. I'm sure there'll be points of view, there will be contradictions, but that's what debate is all about.
Yeah, but Mr. Salve, all of this is happening in a particular backdrop where we have seen the opposition have a singular campaign that the ruling party, the BJP, wants to subvert the constitution. And this has been a political campaign, that there is a subversion of the constitution.
Isn't this an excellent opportunity, Arnab, for people who understand constitutional law to get up and say why they say the government is trying to subvert the constitution? In what way? Not the rhetoric of the constitution, but the principles of constitutional law, which according to them are being transgressed by the government.
But then you also have the specter of the Supreme Court being drawn into this, and the Supreme Court forced to clarify in a particular statement last year or earlier this year that it is not going to fill the space of the opposition.
The trouble with Supreme Court.
Yes.
And I'm sorry they
trouble with the Supreme Court.
Yes, I say there is a problem with the Supreme Court. The judges must go back to the day where judges spoke through their judgments. The trouble is, judges today speak in court, make comments, and if you read the proceeding of the day, it says case fixed on another date. And the media picks it up, and that then becomes a basis for one or the other political group to try and embarrass.
Now, would you blame the media for it or the judges?
No, I blame the court for it.
The judges.
You are there to report what is going on.
You're saying judges are seeking to be headline grabbers.
You must tell the people. You must tell the people that this is what a judge said.
No,
but the judge must not say it.
But the judges have a tendency to be headline grabbers. Is that what you're saying?
They are. I'm sorry to say they are, because they have stopped speaking as much through judgments as they do in comments which they make in open court. And it does create embarrassment. It does create problems on the ground. You've seen it. And why did the court have to go on the back foot and clarify they are not here to play the role of the opposition? Could somebody point out that there is a judgment which you have given which has created this perception? Or does the perception arise out of comments being made by judges when a case is being heard?
Are you saying that judges in the past have been tempted to play the role of the opposition? That they've got swayed with the amount of power that they wield?
You know, the problem, Arnab, is this institution is not meant for this kind of freewheeling debate which goes on in court today. I've said this before, and I'm saying this again. The discourse in the Supreme Court, the vocabulary of the Supreme Court, was never what it used to be 20 years ago. That has to be brought back. That has to be corrected. You have to have issues of law being debated in the court, and judges must hear. If they have questions, they ask. Gratuitous comments about the government or the opposition are all unnecessary. And today, in the world of social media, in the world of transparency, you have to be very careful of what you say. Aren't people in public life careful of what they say? Aren't you as a journalist very careful of what you say? You're a journalist of repute in India. If you make a loose comment today, it will be quoted all over saying Arnab Goswami said this.
Yes.
Don't all of us have to be careful of what we say in this world? Judges have to have a greater responsibility because they do not join the battlefield. They stand away from the battlefield to judge who's got it right in the end.
Times are changing. Even the statue of justice was changed, saying it can't be blindfolded anymore. I mean, you know, these are dramatic.
I have grown up to seeing a statue with a blindfold and a sword, and to me they signified something. So please don't provoke me into saying.
No, what is your view on it? I mean, why you felt that was unnecessary? It was headline grabbing.
Yeah, it was unnecessary.
What was unnecessary?
In today's day and age, let me tell you why. And this is my personal view, and I could be completely wrong, but I think this is my personal view. There are two important signages which have changed. One is the blindfold being removed. The blindfold was put at a time where there was a similar allegation as you hear today, and this allegation will always pervade the centuries, that certain people who are more influential, who are richer, who are more powerful, get more attention of the court than those who are not as influential, as enabled to approach the court. The Lady of Justice was blind to who you are, she only knew the law. And that was what it symbolized. The sword in the hand symbolizes that you strike at injustice where you see injustice. If you have the Constitution is not your only instrument by which you do justice. You have a whole body of law by which you do justice between people. And today, a lot of people complain you don't get relief in the court, but what you get is long judgments which are treaties on constitutional law. So is it that the sword which strikes at injustice has been substituted by a book on the Constitution symbolizing that what you will now get is a beautiful exposition of constitutional law, but maybe nothing in the end?
But you're saying Justice Chandrachud made a mistake?
That was his perception.
No, but I mean, he commissioned the statue, and he said, he commissioned the statue, and he said, law is not blind, it sees everyone equally. Was he trying to,
by not seeing who is in front of you,
yes,
you symbolize that the law doesn't see anyone. Today, one of the biggest criticism is that there is a privileged lot which get a different kind and quality of attention from the courts. This perhaps may not have been the most apposite moment to take the blindfold off. But that's my personal view, and I could be completely wrong, and it's not a matter of a great moment. But before we change certain paradigms by which we have all grown up, this needs a lot more public debate. It needs a lot more discussion. This is not pure symbolism.
Yeah, I mean, this is, but obviously Justice Chandrachud was looking at the symbolism of it, and it was commissioned and then put in place towards the last...
See, this is the trouble, Arnab. We have different perceptions.
Can we not have
a topic which is close to your heart, the change in the preamble. Why did you add the word secular and socialist when the great founders of the Constitution, who devoted so much attention and who put in all the constitutional safeguards, did not use these words? Do you think a person of the learning of Dr. Ambedkar or his advisor B.N. Rao or those who wrote the Constitution were unfamiliar with the English language?
Are you saying that we would continue to be secular if the word secular were not to be there in the Constitution itself or inserted as during the emergency?
The Constitution defines in Article 14 and Article 25 and Article 26 and Article 30 how rights of different denominations, and I'm deliberately not using the word minorities because the Constitution goes beyond and protects every denomination. The Constitution provides for every denomination. Why do you want to use words which are of general use and which may have different shades of meaning to different people? Do you think Dr. Rao or Baba Sahib Ambedkar hadn't heard the word secularism? Why did they not use it? Socialist. What do you mean by saying it's a socialist republic? Today, republics like certain republics in Europe, in one sense, are far more left of center than a country like India is. But they don't call themselves socialist republics. Socialism also has a different connotation where human rights are considered secondary to certain social norms. That is why the framers of the Constitution, who put our trilogy of articles, 14, 19, and 21, the right to life, the right to your 7 freedoms, and the right to equality. They call it the golden triangle. This is the basic structure of the Constitution which you can't fiddle with. All this fits very ill with these kind of loose expressions like a socialist republic. According to me, India is already a little too socialist. We should be more right of center. According to you, we may be too much right of the center. We should be more left of the center. So can you, I mean, tomorrow you might as well put in the preamble, India shall be centering and not a leftist or a rightist economy. Will it make any sense?
No, I think it's self-serving. I think personally, I think it's self-serving, it's elitist. And you're thrusting something which was not there, which in the
Constitution should also accommodate. If the Constitution can accommodate Mrs. Gandhi bringing in leftists, if the Constitutions can accommodate communist people getting elected to Parliament and in theory forming a Parliament and nationalizing, the Constitution must also accommodate people who believe in free trade, people who believe in free enterprise, people who believe in laissez-faire. The Constitution doesn't decide how the country is going to run. The people of India vote for those who, at the times, represent the aspirations of the people. The Constitution is not meant to compel future generations to run India in a particular way.
So should I mean, if we're looking at the India of the future, should we drop the word secular and socialist from the preamble of the Constitution?
We have to drop a bad habit which we have gone into. Every time things don't work, we amend the Constitution.
Now, of the 106 amendments made till date, over 80 amendments have been made by the Congress party, including the 42nd Amendment.
Mr. Palkhiwala, my late guru, used to use a very interesting expression. He said there is a famous saying, a bad workman always quarrels with his tools. If you can't get the country to work.
No, 1 minute. You're very intelligent. You're dodging my question. My question is, should the word secular be removed? I am asking Harish Salve a straight question. Should the word secular be removed from the Constitution?
For 2 reasons. I'm sorry, 2 reasons. Not just secular. Secular and socialist both
should be removed.
For 2 reasons. The Constitution's substantive provisions inspire people to run the country on the basic structure of the Constitution, which is already embodied. You don't need loose expressions in the preamble. And secondly, I am of the view, and of course, I could be wrong, but Mr. Palkhiwala's school of thought, that the Constitution is a statement of a historical fact. The people of India gave to ourselves this Constitution. It was a statement of a historical fact. In fact, there is no business changing the preamble. So, for various reasons, and it's wrong on so many levels, Mr. Palkhiwala used to give 3 arguments on why this preamble should not have been amended. One was, if the framers of the Constitution, for good reason, did not use words like secular and socialist, please do not add these words. And you have seen, history has proved, these words have not served any good purpose.
Yeah.
Second, the preamble is a historical fact. It says the people of India give unto themselves this Constitution. You cannot change that. And the third very lyrical thing he used to say is, the preamble is beautifully stated. Can you improve on Shakespeare's "the rest is silence" by saying that the rest is complete, absolute and total silence? No, you can't. You're adding verbiage.
But now government won't do this. Government, I don't think, will remove the word secular or socialist, because if it were to happen, then you would have people taking a copy of the Constitution in their hands and going around the entire country on an election campaign saying, see, we told you so, this government will change the basic structure of the Constitution. So my follow-up question to you, Mr. Salve, is...
But they can still say that, right, if they have a blank booklet in the hand?
They can. Yes, and by the way, it is a blank booklet, isn't it, Rhythm? It's a blank booklet most of the time. But you see, Rhythm, what we must get, if the word secular and socialist goes away, and I think it would be a much better constitution if the word secular and socialist were to go away, would the opposition not make this a huge political issue?
Of course they would.
That the whole basic structure of the Constitution is being changed.
For the government to do, politically wise for the government to do, is not something which I'm saying. You ask me as a student of Constitution.
No, but technically, would it go through challenge? It would go through challenge. The judges in the court. There was something which came up 10 days back or 12 days back in Parliament, and you saw it was dismissed. by the Supreme Court.
That again is misconceived.
Why is it misconceived?
This is not something for judicial review. It is not that you cannot amend the Constitution. You can amend the preamble because it doesn't affect the basic structure of the Constitution whether you add or don't have these words. In fact, that's my whole point. So if you've amended it and added something, you've not damaged the basic structure of the Constitution. And that's the only limitation. The biggest limitation on Article 368 is the wisdom of Parliament. The courts only come in when you go beyond the basic structure. An unwise amendment is still a lawful amendment.
Yeah.
An unnecessary amendment is still a lawful amendment.
Yeah.
What I'm saying is, as a student of constitutional law, you shouldn't have done it. Can the courts come in? Certainly not.
Yeah. Yeah, please.
Yes, Mr. Salve, one question. You've now said that the appointment of judges in India needs to be changed. It's time the collegium system is changed. You've also spoken about judges speaking outside the court. I want to draw your attention to one former judge of India, Justice of India, who spoke at an event where he spoke about the Places of Worship Act and he spoke about the Babri verdict, which he was not even a part of, and he tried to dissect it, criticize it. Isn't this becoming a commonality? You also spoke about the special privileged lot.
Speaking of the judges, I'm sure you were talking about the judges, wasn't it?
Yes. So isn't it time, like Arnab asked you and like you said, the judges need to be held accountable for their words inside and outside the court?
See, in fact, Rhythm, what you're asking is something extremely important. As we always heard, what are the law and contempt put in place for? Judges used to always say, don't criticize us, criticize our judgments. But that is on the premise that they only speak through their judgments. Judges always say, please do not drag us into a political debate. But then that has to be on a premise that the judges do not make political comments. Whether or not a judgment like Ayodhya is right or wrong is a subject a judge should best stay away from. It is the judgment of 5 judges. You may agree, you may not agree. As a student of constitutional law, I may write a strong article supporting it, or I may write a strong article disagreeing. I'm right now writing an article strongly disagreeing with the Aligarh Muslim University judgment, but that's my prerogative. I'm a student of constitutional law. I can say, I'm sorry, the Supreme Court got it wrong. So that is a very different matter. The judges, by and large, do not comment on judgments of this kind. It was a judgment given on the facts of a particular case. It was not a principle of constitutional law which was being criticized. And I think it is best if judges do not enter the domain of public dissent. Otherwise, then don't take offense if somebody who is in public life attacks you personally, because you are entering. Do not enter a hockey field or a football field and say we must play by the rules of cricket. It doesn't work that way.
Yeah. So judges both want the privilege of appointing themselves, want also to sway public opinion beyond the scope of their judgments, and are tempted to do so. But would you blame the judges? Because every constitutional issue is coming before the court. Is the Places of Worship Act constitutional, for example? Should Hindus have no right to reparations and reclaim their own cultural heritage that was destroyed by invaders and tyrants over centuries? This is both a constitutional issue, but more a political issue.
No, let me tell you.
Why not?
If the judges hear this case without unnecessary comments, of course you would ask questions if you have any doubts. But everybody will be hearing, watching, immediately motives will be, or projections will be made of who's thinking how. So you have to be very careful of how you hear these cases. And then your judgment must speak for itself. You may say that the law is valid, you may say that the law is unconstitutional, or you may say certain parts of the law are valid, certain parts of the law are invalid. Your judgment should make compelling reading. Not that everybody needs to agree with your judgment, but everybody should say, well, there is very good reason for what the court has said. Say that and say no more.
So
that is the way to deal with highly complex commercial these disputes. Let me give you two examples, Arnab. At the Brexit time, two very important cases were heard by the UK Supreme Court. And you know, this was a very emotional issue in the United Kingdom. The first was whether the executive government could give effect to the result of the referendum without going back to Parliament. And the Supreme Court heard the case and said, no, you have to go back and get a parliamentary vote. That was followed very shortly by something which even now some people criticize in the UK, that it was a step too far. When Boris adjourned the House and the Supreme Court said it was done on the wrong advice and therefore the House had to be recalled. Those cases were heard. You should have seen nobody criticize any judge personally because there were no comments. The court spoke through its judgments. The US Supreme Court has dealt with George Bush's election. It has dealt with Trump's election challenges, etc., etc. Have you ever heard any US judge talking in a public forum about Bush or about Trump or about Harris or about the Democrats or Republicans? Never. They only speak through their judgments. That is how they also deal with questions which are of great public moment without getting involved in the public controversy. And I think it's time we got back into that discipline.
But there's a lobby in the Supreme Court of a few lawyers, very often disgruntled, who have had political aspirations in the past. Some of them joined political parties, failed and came back, who want to make the Supreme Court a lever over the government. Now, this changes the whole, and in the context of this changes the whole balance, because the Parliament is supposed to frame the laws, the courts are supposed to interpret the laws. Now, I would argue, Mr. Salve, that Parliament would hesitate to frame the laws, even if it has a mandate, because there's a feeling that every single subject, important or unimportant, will be brought before the Supreme Court. So even before you start thinking of what laws to frame for the good of the country, even if it is the Supreme Court, even if Article 44 recognizes the need for a uniform civil code, the first thought that goes into the lawmaker's mind is, oh, we are going to have to face the court. And the courts never say that this is a matter beyond us. The courts never hesitate to draw the line on themselves, because they're also being egged on by a lobby, you see, within the courts of lawyers and advocates.
It's again ironical. I always say this, and I think as a student of constitutional law, I'm entitled to say this. There was a time where we had a coalition government, and which was known for hiding behind the Supreme Court for every controversial decision. The one sentence which I have quoted on multiple interviews is when the Ayodhya case was being heard and the mob had collected outside the disputed structure. The case was heard by Justice Venkat Chalaya, and the then Attorney General said, "My Lord, my forces are there waiting for your Lordship's command." Justice Venkat Chalaya told him, armed forces are commanded by their commanders, they're not commanded by the Supreme Court.
Yeah.
What was the message that they were giving to the Supreme Court? That you are the ones who should decide the law and order of this country.
Correct.
We don't want to take responsibility of any political decisions. You do it. Now, if you encourage judges more and more to get into areas which you don't want to decide because they are politically a hot potato, then the next time the judge will do it voluntarily, then don't complain that there's overreach by the court. The whole structure has gone awry. And this needs to be fixed. And that is what our lawmakers, when they discuss about the Constitution, should sit down and discuss. How do we get the institutions back in sync, rather than institutions, as you're rightly saying, at apparent loggerheads, that when Parliament sits down, they are worried about the Supreme Court.
Yeah.
When the Supreme Court takes on a case, they are worried about what will be said about them by politicians.
No, I think that's brilliant. I think we've covered a lot of ground. This is so useful. I think we're going to put out this interview rhythm on all platforms, digital, television. because you need context for the ongoing debate on Parliament, and nobody better than Mr. Salve to share it with us. Privilege, wonderful. Thank you, and look forward to seeing you personally soon, Mr. Salve. Thank you so much. Thank you, sir.
Thank you.
Thank you, sir. Thank you.